This morning on the Ag Issues program, a pleasure as always to bring on to the program Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine, thank you.
All right, let's get to it. And this is just something you posted on your blog this morning, as you call it, the Property Rights Edition of the Ag Issues program. And it's not often we get to talk about cranberry bogs, but you have a case specifically looking at cranberry bogs and the Clean Water Act.
Yeah, Greg, and what we're talking about this morning is just a snippet of a keynote address I'll be delivering later this week to the Idaho State Bar Association in Boise, Idaho. And my subtitle on my presentation is Reimagining Productive and Prosperous Agricultural Producers in Rural Communities. And again, what I'm writing about this morning is just probably less than 10% of my total presentation out there. But there are some really big property rights issues that are going on in the courts, in the legal system in general right now. And the first one has to do with cranberry bogs and rice farming. And you may think, well, why are we talking about this in Kansas? We don't raise cranberries. We don't raise rice. What's the issue here? Well, this has really broad implications depending on how the courts view this, because under the Clean Water Act, you have to have a discharge permit to discharge pollutants from a fixed point into a navigable water of the United States. So we bring WOTUS back into this. And not regulated is runoff from irrigation activities on farms. There is an irrigation return flow exemption. And historically, the EPA has interpreted that to include runoff from irrigated dryland crops, rice farming, and cranberry bogs. So there's your first tie with respect to the irrigation return flow exemption right there. It applies to dryland crops. Well, that's a lot in Kansas. So what that means is you don't have to have a Clean Water Act permit for those activities. However, there has been a case filed against a Wisconsin cranberry farm that claims that the discharges involved should not be exempt under the irrigation return flow provision. And what they're claiming there is that a channel and ditch are point sources of phosphorus and sediment discharges, which are under the Clean Water Act a pollutant, because that is defined very broadly under the Act. And so they're claiming those discharges of phosphorus and sediment into a nearby lake when the bogs are drained should not be exempt under that irrigation return flow exemption, because the claim is that the bogs are not used for irrigation. They are used to aid in the overall growing process and protect the cranberries from freezes and harvesting. So that case, again, we don't have any decision on this. It was just recently filed at the very end of February. But, Greg, you could imagine what a ruling against that farm could mean in terms of its impact on the cranberry and rice industries involved nationwide. Plus, depending on how the court would rule on this, would that also take out the irrigation return flow exemption from crop growing activities on dry land? So we shall see. That's a big one to keep an eye on.
Yeah, absolutely. Specifically when water issues, because cranberries and rice obviously use a lot of water. If you've ever seen on video of cranberry bogs, you know exactly what that means.
Yeah, that's a big issue. It's huge. I can't overstate how important the court's decision in that one will be.
Yeah, absolutely. All right, let's go to another issue, and I'm sure many people have heard about PFAS. What they are used for, the chemicals, but also how much of it have been linked. The studies have linked exposure to PFAS to harmful health effects in humans and animals, but how this could affect what PFAS, how they're regulated, how they're looked at, and also rural landowners.
Yeah, this is a big issue. I would say if we've got any Kansas legislators listening in this morning, they need to have their ears perked up on this one, because there's a role for them to play in this in terms of being proactive and taking a preemptive position on this one. Because we've had in essence, a Michigan farming operation completely destroyed because of something that the state has done here. And so let me explain this. So a PFA is a widely used, long-lasting chemical that has components that break down slowly over time, and it's found in water and air and soil all over the globe. So it's nothing new. It's all over the place. But as you indicated, there are studies out there that have linked PFAS to harmful health effects in humans and animals. They are a group of more than 15,000 chemicals that are associated with various cancers and other health problems. Well, these things don't break down quickly. As I said, they break down slowly over time. And I think the biggest potential problem area for agriculture involving these is likely biosolids. That's the solid matter that remains at the end of a wastewater treatment process. And those are often used in agriculture. They're land applied. There are benefits to doing so. It is a cost-effective fertilizer for many farming operations, and it recycles nutrients and fertilizers and creates those cost savings on chemicals and fertilizers for farmers. Now, the uptake of PFAS by plants will vary depending on the PFAS concentration in the soil and the water type, the type of soil, how much rain you get or how much irrigation you have, and the type of the plant. They are listed as a hazardous substance under CERCLA, the Superfund law, and that can be a major concern, of course, for rural landowners. Now, what's given us a pause for concern with respect to these is that in 2022, there was a Michigan 400-acre cattle farm which has been owned and operated by the same family for over 100 years. They were forced to shut down due to high levels of PFAS in the beef products from their cattle and in the soil at the farm. Testing revealed that. And the farm had received, like many farms do, biosolids from a municipal wastewater treatment plant to fertilize their crops, which they would later harvest and then feed to the cattle. And so the cattle were sold, the beef products were sold, they're tested, they tripped the tolerance levels, and now this fellow can't sell his cattle, and he has no market for crops that are harvested from his farm. And he can't dispose of the cattle either, so he's still having to feed and incur the expense to feed about 150, 160 head of cattle that he can't do anything with. Now, normal screening is done for pathogens and heavy metals, such as lead and arsenic and mercury, but most states don't test biosolids for PFAS. However, Michigan does conduct extensive PFAS investigations that include testing municipal water systems and watersheds that have suspected contamination. Where this contamination came from is really the problem here in this one, Greg. And this is why legislators need to pay attention to what's going on here. This was of no fault of the farmer at all, and now he's completely destroyed. He's sliding into bankruptcy, and he has no way to sell his product. He has no way to produce any income from that farm. There was an auto parts supplier that was responsible for this contamination, and now the farm has sued that auto parts supplier for putting chromium, hexavalent chromium, into the wastewater system that contaminated the biosolids, which then he purchased from the wastewater treatment plant. And so he's seeking tens of millions of dollars in punitive damages to help cover the cost of remediating his farm's soil and groundwater. So the question on this one, Greg, is whether Kansas tests for PFAS in wastewater, and no, they don't. KDHE does not do that testing. Now, sampling has occurred on a select number of mechanical wastewater plants for PFAS in plants in their effluent since 2022, but KDHE has not sampled biosolids from those facilities yet, and that's the thing. And some states on this issue have taken preemptive action. Maine bans land application of biosolids and sets up a fund for impacted farmers that have been impacted by this through no fault of their own. Other states are looking at taking preemptive action too, and that's something Kansas probably should look at because this issue is going to be coming here sooner rather than later.
Talking property rights issues, and with Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, I had not heard of the Quiet Title Act, But in this case, the implications for property rights, this specific case, the Quiet Title Act is not jurisdictional.
Yeah, and I'm not surprised that you hadn't heard of it. Very few people have, but it is the way that the Supreme Court construed a procedural provision in the Act is a very important point for landowners, particularly out west. But because sometimes farmers and ranchers, particularly as you get further west in the country where the federal government owns a much higher percentage of land area out there, you can find yourselves in various legal battles with the federal government. And what you had in this instance, you're in western Montana, and you've got a couple of landowners that live along a dirt road that provide access to a national forest from a public highway. Well, the prior owners of the land granted the federal government an easement back in 1962 across the land by means of a road to provide the government timber contractors access to the forest from the highway. That's the only way they could get access to the forest, was to have this road by virtue of an easement across these private landowners' paths. So, because a lot of times you're going to get that government land that abuts your land, or it crosses your land. There's kind of a checkerboard patchwork quilt of this in the West. And the deeds and the accompanying letter said the purpose of the road was for timber harvest. Well, everything was fine for about 45 years. The government's use of the easement didn't interfere with the landowner's property. Then in 2006, the government put up a sign. The federal government posted a sign. This would be the National Forest Service, saying that the road provided public access through private land. Now, just think, Greg, how would you feel if you wake up one morning and you're on your property, and now you see this sign out there that says, this is public access? So you're going to have a problem now with the public thinking that they can come across your property to access the national forest. Well, they can't. That's not the purpose of the original easement. So they couldn't get this thing resolved. And so in 2018, that happened in 2006, 2018, they filed a lawsuit under the Quiet Title Act, which allows a private landowner to sue the federal government for intrusion on their private property if you bring the lawsuit within 12 years of the claim, as to when the claim incurred. And in this instance, that would be 2006, we would think, when the government expanded the scope of the easement. Well, they sued in 2018, and that was just outside that 12-year window. And so the government claimed, well, courts lack jurisdiction, they can't hear the case, too bad, so sad, you're out of luck.
All right, as we get into the latter part of the program here, Roger, we had briefly got into some of the issues or some of the regulations just to remind people of when they are pasture burning, and that is definitely one of the things that we're in the heart of right now as well. But I want to get a little deeper into the Flint Hills pasture burning that we normally see this time of year, and some of the things that you had mentioned last week, but just some more reminders and some things to think about if you are a rancher farmer out there who does annual pasture burning here in the Flint Hills.
Yeah, and let me say before we jump into that, if we've got a few seconds, I want to kind of tidy up the last issue, and left it there with the landowners suing, and they lost that case in the trial court, and then on appeal at the Ninth Circuit, because those courts said that the Quiet Title Act, that provision, that 12-year provision, is jurisdictional, which means that's a time bar. You got to sue within 12 years of the time of the intrusion by the federal government. But the U.S. Supreme Court reversed on that issue and said in a 6-3 opinion that is not jurisdictional. That is a procedural rule. Now, there was a dissent, and the dissent said, well, this is a sovereign immunity issue, and so that is a time bar. But the majority did not. So they were not barred from court, and they will get their day in court to hear about this intrusion that they're alleging the federal government has made on their land. Again, I can't overemphasize how important that conclusion by the Supreme Court is. The Supreme Court pointed out that property rights are a fundamental constitutional right. The doctrine of sovereign immunity is a doctrine. It is not found in the Constitution. And so here we had private property rights trumping the sovereignty issue on a procedural matter. Very, very important, particularly for landowners out west. That could turn out to be a key case in the battle of property rights. I just wanted to throw that in, Greg.
Yeah, absolutely. And as we wrap this up, of course, if you're pasture burning right now, many things to keep in mind as far as staying within the bounds of what you need to do when you're out pasture burning.
Yeah, and of course we have the Kansas administrative regulations which govern this heavily, and so people need to pay attention and always comply with those regulations. I recently, a couple of weeks ago, posted a piece on my blog that gives in detail what those prescribed burning regulations are all about and the rules that apply, particularly when you're in the Flint Hills. But in terms of legal liability principles, the regs require ag prescribed burns to be supervised until the fire is extinguished. But as you and I both know, sometimes a fire will get out of control even after it's believed to be extinguished and burn an adjacent property and result in property damages. So how does the law sort that out? Well, in Kansas, we have some pretty good case law that protects property owners, agricultural property owners, from lawsuits in this type of an instance because the rule is not one of strict liability. The rule is one of negligence, and so a damaged party would have to show that you were negligent in the manner that you conducted your burn to hold you liable. Now, one way they do that is by showing that you didn't follow the administrative regulations for conducting your burn and keeping it controlled. And so it's very important to follow those administrative regulations that have been set up to govern these in Kansas. But that's a key point. That it is negligence, it's not strict liability. You have the right to conduct an agricultural burn, but you've got to do so in accordance with the regulations.
All right, Roger, we had just mentioned or at the start of the program that you had just posted all this information on your blog, and you had mentioned this is part of your address that you're going to be doing in Idaho later in the week. But if people want to read more, where can they go to your blog to find this information?
washburnlaw.edu/WALTR, and in a few moments I'll send it over to K-State, and it'll be posted on Ag Manager website. That's the website for the Department of Ag Econ.
All right, sounds good. Roger, as always, very much appreciated. Safe travels up to Idaho, and we'll talk to you here in a couple of weeks.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us this morning on the Ag Issues program here on 580 WIBW.